Welcome to the debate. Today we are stepping into the Supreme Court of the Bronx to examine a really fascinating collision between objective medical reality and professional credibility. We're dissecting the sworn testimony of Dr. Joseph Weinstein in the case of Buestan v. 550 Washington Owner LLC. And the central question we are grappling with is this: can the objective success of a surgical intervention, a patient visibly recovering, be separated from the significant ethical and procedural clouds surrounding the surgeon who performed it?
It's a case that really forces us to ask what we value in expert testimony. Is it the technical skill of the hands holding the scalpel? Or, is it the integrity of the whole system that put the scalpel there in the first place? We have a patient who, by all accounts, got better, and a doctor who's been effectively blacklisted by the very system designed to protect injured workers.
Exactly. And I am here to argue that the medical evidence in this case, the pathology you can see on the MRIs, and the undeniable recovery of the patient, it validates Dr. Weinstein's testimony. My stance is that when you strip away all the administrative drama, you have a surgeon who identified a problem, fixed it, and gave a man his life back.
And I'm here to argue that you simply can't strip away that context. I'm looking at a doctor who lost his authorization to treat injured workers because of a pattern of unjustified procedures. A doctor operating within a high-volume business model, and a diagnosis based on a patient history that we now know was demonstrably false. To me, that fundamentally undermines the reliability of anything he says on the stand, regardless of the outcome.
Then let's get into the evidence. My position is it's grounded in the tangible. In a courtroom, it's very easy to get lost in character attacks, administrative rulings. But at the end of the day, we're dealing with biology and physics. Dr. Weinstein's testimony wasn't just an opinion. It was a guided tour of a broken body. He walked the jury through MRIs showing a spinal cord that was physically compressed, squashed flat. He identified specific markers of an acute injury that correlated perfectly with the patient's pain. The patient, Mr. Buestan, was a demolition worker in agony, an 8 or 9 out of 10 on the pain scale. He underwent 2 major surgeries, an anterior cervical discectomy and fusion, and a lumbar fusion. The result? He's traveling internationally. He's looking for work. His pain is mild. My argument is that a witness can have administrative baggage and still be a brilliant technician. The fused spine speaks for itself. You can't fake a good outcome in spinal surgery.
I appreciate the focus on the outcome. I do. But my position is that the process determines the truth. We have to talk about the concept of garbage in, garbage out, which the defense attorney, Mr. Rosenzweig, pressed pretty hard on. Dr. Weinstein admitted that his determination of causation, linking the injury to the accident, relies heavily on the history provided by the patient. In this case, the patient claimed he had no prior neck or back pain, none. But the records show 4 years of treatment for neck and back pain before the accident. So Dr. Weinstein operated on the premise that this was a fresh injury, based on a lie. And when you combine that with the financial incentives, he makes roughly $80,000 a week in surgeries and was paid $10,000 just for this testimony. And the fact that the Workers' Compensation Board revoked his privileges for doing too many unjustified surgeries, I simply don't buy that we can trust his judgment. A broken clock might be right twice a day, but you don't use it to time a space launch.
I want to start with your broken clock analogy because I think it mischaracterizes the precision involved here. Let's look at the diagnosis itself. You mentioned the garbage in, garbage out theory, that because the patient lied about his history, the diagnosis is flawed. But Dr. Weinstein didn't just rely on what the patient said. He relied on what the MRIs showed.
But MRIs are static images. They require interpretation, and that interpretation is subjective.
To a degree, but there are objective markers. Dr. Weinstein pointed out something very specific on the lumbar MRI, a high-intensity zone, or HIZ. For our listeners who aren't radiologists, let's break that down. Think of the spinal disc like a jelly donut. It has a tough outer wall and a gel center. When that disc tears, fluid leaks into the outer rim. On an MRI, that fluid lights up bright white. That's the high-intensity zone.
Okay, so he sees a white spot.
He sees a glowing signal of trauma. And here is the key. An HIZ specifically indicates an acute tear, a fresh injury. It is not something that sits there for 4 years while you play soccer. It's the difference between a tire that is bald from old age and a tire that has a fresh gash from a spike strip. Weinstein saw the gash, and that physical evidence, well, it overrides the patient's verbal history.
That is a compelling image, but let's look at the timeline of how he found that gash. This goes to the integrity of the diagnosis versus the assembly line accusation. Dr. Weinstein admitted under cross-examination that he recommended a massive surgery, an anterior cervical discectomy and fusion, an ACDF, after a single consultation on September 2nd, 2020. And that consultation lasted about 30 minutes. 30 minutes to decide to cut open a man's throat, move his esophagus aside, remove a disc, and screw a cage into his spine. That feels less like a considered medical opinion and more like a factory floor decision.
I understand why it sounds fast to a layperson. I do. But in high-level surgery, speed of decision-making often correlates with proficiency, not negligence. If I'm having my spine fused, I don't want the doctor who needs 3 hours to figure out what he's looking at. I want the guy who has seen it 5,000 times and knows it in 5 minutes. Weinstein was very clear about what he saw in those 30 minutes. He described the spinal cord at C4, C5. He used a really visceral image. He told the jury the cord looked like a jelly bean.
The jelly bean quote, I remember that.
It's important because it paints a picture of deformation. A healthy spinal cord should be round in cross-section. Weinstein showed that this cord was flattened into a jelly bean shape because of the pressure. That isn't a maybe. That is a physical deformity of the central nervous system. When you see a cord compressed like that and a patient in 9 out of 10 pain, you don't need 3 hours to recommend surgery. You need to get them to the OR.
But does the volume of his practice suggest he's looking for reasons to get them to the OR? He admitted he couldn't even give a straight answer on how many surgeries he does, but eventually conceded it's around 8 a week at roughly $10,000 a pop, plus the facility fees, plus anesthesia. That is an $80,000 a week revenue stream. The defense argued this suggests a business model prioritizing volume. And when 60 to 70% of his practice is work-related accidents litigation cases, you have to wonder if he sees jelly beans because they're profitable to see.
Or maybe he sees them because he is the guy lawyers send the complicated cases to. Volume leads to expertise, and the post-op evidence backs this up. The X-rays showed the hardware was placed perfectly. The fusion took. The patient regained the ability to heel walk and toe walk, which tests specific nerve roots. You can call it a factory, but it seems to be a factory that produces high-quality repairs.
A high-quality repair of a defect that might not have even been caused by the accident. And this brings us right back to the garbage in, garbage out problem. You can't just wave away the missing medical history because the screw placement was good.
I'm not waving it away. I'm contextualizing it.
Let's look at the transcript. Mr. Rosenzweig, the defense attorney, asked Weinstein directly, if the history provided is not accurate, the determination of causation is compromised, correct? And Weinstein had to say yes. It's a logic trap. The patient, Mr. Buestan, was a demolition worker. He played soccer weekly. The defense produced records from a Dr. Lal showing 4 years of treatment, trigger point injections, physical therapy, consistent pain complaints from 2014 to 2018. Weinstein didn't have those records. He admitted that without the MRIs from those prior years, it's impossible to know for sure if these herniations pre-existed the accident. He is essentially guessing that the falling ceiling caused the injury based on the word of a man who lied about his medical history.
That is the defense's strongest logical point, I'll grant you. But Weinstein addressed this on redirect, and I thought his answer was savvy. He argued that even if he had seen Dr. Lal's records, it wouldn't have changed his surgical recommendation.
That just sounds like hindsight bias. Oh, I would have done the same thing anyway. How can he possibly justify that?
Because of the high-intensity zone we just discussed, he argued that the prior treatment was for chronic aches, wear and tear typical of a laborer. But the 2020 MRI showed that acute, bright white tear. He testified that the acute finding is distinct from the chronic history. Basically, a guy with a bad back can also suffer a new catastrophic injury. The existence of the former doesn't disprove the latter.
Acute is a very convenient diagnosis when you're incentivized to operate. And that brings us to the elephant in the room. We have to talk about the Workers' Compensation Board. This isn't just a difference of opinion. This is a regulatory body slamming the door on him.
It's certainly the most dramatic moment of the cross-examination.
It's damning. The defense revealed that Dr. Weinstein's authorization to treat injured workers was not renewed. The board issued a 20-page letter detailing why. They found a pattern of performing procedures in a quantity or frequency greater than recommended and lacking medical justification. Let's really pause on that. The system designed to pay for these surgeries said no more. You are doing too many unnecessary surgeries. This isn't just a paperwork error. This is the board saying, we do not trust your medical judgment. If the state doesn't trust him, why on earth should a jury?
I'm not convinced by that line of reasoning because it ignores the specific checks and balances that happened in this specific case. Dr. Weinstein testified that every single surgery he performed on Mr. Buestan was pre-approved, and not just by a rubber stamp. They were approved by the insurance company's own doctors, the independent medical examiners.
That is a fair point. The defense didn't dwell on that.
Because it hurts their case. Think about it. The insurance company has every financial incentive to deny the claim. They hired their own doctors to look at the same MRIs Weinstein looked at. And those hostile doctors said, yes, this surgery is necessary. If the opposing side's doctors agree the surgery is needed, then the board's general administrative ruling about his pattern becomes, well, almost irrelevant to Mr. Buestan. It proves that in this instance, Weinstein was right.
I just don't buy that the board's ruling is irrelevant. The board looks at the aggregate. They look at the business model. And even if an IME approves this surgery, the fact that the surgeon has lost his license to treat this entire class of patients suggests the systemic rot. It paints a picture of bias, that Weinstein is biased toward profit over patient welfare. And look at Weinstein's defense on the stand. He didn't say, I learned from my mistakes. He said, I'm suing the state. He called the board's findings certainly not true. To me, that doesn't exculpate him. It just highlights that he is a man fighting to protect his revenue stream.
Or it highlights that he believes he was treated unfairly by a bureaucracy. But let's pivot to the ultimate evidence. The outcome. This is the proof is in the pudding argument.
The all's well that ends well defense.
It's the only defense that matters to the patient. Mr. Buestan is traveling to Ecuador. He went to the Dominican Republic. His physical exams, negative Hoffman's test, negative Clonus, showed that the pressure on his spinal cord is gone.
Can we quickly clarify those tests? Hoffman's and Clonus?
Sure. These are objective neurological tests. For a Hoffman's test, you flick the patient's middle finger. If the thumb twitches involuntarily, it implies irritation of the spinal cord in the neck. Clonus is similar but in the foot, rhythmic beating when you push the foot back. Mr. Buestan had these signs before surgery. He does not have them now. That is objective proof that the surgery decompressed the cord. The treatment worked. If Dr. Weinstein was just a surgery mill looking to bill $80,000 a week, you'd expect sloppy work or unnecessary procedures that don't result in such dramatic improvement. Here, the man got his life back.
But does the end justify the means? That is the ethical question at the core of this. The defense raised a concept that I think is crucial here. Surgery maximizes the value of a lawsuit.
The litigation premium.
Exactly. For those listening who might not be in the legal field, there's an economic reality to these cases. A personal injury case where the treatment is just physical therapy, what they call conservative treatment, that might be worth $50,000? But a case involving spinal fusion, where you put titanium hardware into a human body, that value skyrockets. We're talking $500,000, maybe more.
It raises the stakes, certainly.
It incentivizes the entire ecosystem. If a doctor is known for being aggressive with the scalpel, that doctor becomes very popular with personal injury attorneys. We know Weinstein gets referrals from these firms. So when he sees a jelly bean or a high-intensity zone, is he seeing a patient who needs help, or is he seeing a way to turn a $50,000 case into a $500,000 case?
That is a cynical question.
It's a necessary question. If the surgery wasn't truly necessary at that time, then it's a bodily invasion for profit. You mentioned he's better, but was he better because of the fusion, or would he have gotten better with time and proper conservative care? We will never know because Dr. Weinstein operated after one 30-minute consult. The defense's implication is that the surgery is a tool for litigation, not just a tool for healing. And when you have a doctor who is paid $10,000 just to sit in that chair and testify, who charges for narrative reports, and who relies on attorneys for referrals, the success of the surgery feels like a convenient byproduct of a profitable ecosystem.
If the surgery fixes a broken man, does the motive matter? I think that view ignores the radiology. You cannot fake a compressed spinal cord on an MRI. You cannot fake a high-intensity zone. You can argue about incentives all day, but titanium screws don't lie.
But you can ignore the context that created the need for them. You can ignore the years of prior trauma that might suggest this wasn't caused by the falling ceiling. That is where the garbage in, garbage out argument lands. If the accident didn't cause it, but Weinstein says it did because he ignored the history, then the lawsuit is built on a lie, even if the surgery was technically successful.
And yet, on redirect, Weinstein held his ground. He stated clearly that he wouldn't have operated back in 2017 based on the Dr. Lau records because there was no MRI and conservative treatment hadn't been exhausted. He differentiated his care. He didn't just operate because he could. He operated because the diagnostic testing in 2020 demanded it.
And I'll give you that. He held his ground. He was combative even. He refused to give ballpark numbers on his testimony frequency. He fought the judge on the soapbox moments regarding the insurance companies. He is a man who believes he is right, but confidence isn't credibility.
No, but competence is credibility. And the x-rays, showing the screws in the right place, the fusion healing, and the patient walking without pain, that is competence.
Competence in execution, perhaps, but competence in judgment? That is where the Workers' Compensation Board revocation casts a very, very long shadow.
And this brings us to the summary of our conflict here. We are left with two versions of Dr. Weinstein. We have the skilled technician, the man who produces successful fusions, identifies subtle pathology like the high-intensity zone, and leaves patients happier than he found them.
Versus the controversial figure, the man with revoked privileges, who accepts incomplete histories, operates at a volume that raises eyebrows, and sits squarely in the middle of a litigation machine that profits from aggressive treatment.
The difficulty for the jury, and for us, is deciding which lens to look through. Do they trust the expert's hands, the physical evidence of the MRI?
Or do they trust the business model, the incentives? Is it possible for a witness with that much financial bias and that much administrative baggage to still tell the medical truth?
It suggests that there is a gray area in expert testimony where truth and incentive might actually coexist, however uncomfortably.
Indeed. And it encourages us all to look much closer at the source material, because the devil is always in the details, or perhaps in the missing medical history.
Thank you for joining us for this exploration of the surgeon, the spine, and the credibility gap.
Until next time.
Goodbye.